Hi guys, welcome back to my channel. This is Battle with Ola. My name is Mojola Olua and welcome to another episode of Ask Me Anything Legal on Battle with Ola. So someone asked a question on civil appeals, asked about the time and the originating documents, the documents to file. And so I'm just going to do a thorough job about explaining civil appeals in general. I hope to cover as much as possible because civil appeal is one of the widest, topics in law school, and it's very important for lawyers who go to the appellate court. Any lawyer that is in litigation will need it because at some point you might have to appeal, and it's also good for laymen to understand, the nuances and the intricacies of appeals in Nigeria. So what's an appeal? An appeal is a process by which you ask a higher court or an appellate court in Nigeria to review the decision of a lower court. Now, it could be an interlocutory decision. That's a decision within, a suit. That is maybe a ruling, or it could be a final decision, that is the judgment, the final decision in the matter. So the process by which you ask a higher court or an appellate court to review the decisions of a trial court or a lower court is called appeal. So you can appeal from a magistrate court, for instance, to the high court, and from the high court to the court of appeal, and like that. But essentially, all these courts that I'm about to mention appeal to the court of appeal directly. A state high court, a federal high court of the FCT, customary court of appeal, Sharia court of appeal, national industrial courts, national and state election tribunals, governorship election tribunal. All of them appeal to the court of appeal directly. Now let's talk about the time frame. For all criminal matters, 90 days is the time within which to appeal. That is, if the judgment was given today, you have 90 days within which to file an appeal on that judgment, on that decision. That's for criminal matters. But for civil matters, the time frame differs a bit. For civil matters, the time frame within which to appeal is 3 months. Now, 3 months is different, very different from 90 days. And that's very important because if you're at the Nigerian law school, it could come up in your MCQ. 3 months is different from 90 days. 90 days is just 90 calendar days, you count it. But 3 months, a month could have 29 days, 30 days, or 31 days. So they are different. Do not mix it up. So if you're appealing from the magistrate court to the high court, you must appeal within 30 days for a civil matter. But if it's from the high court to the court of appeal, you must appeal within 3 months. But if it's from the court of appeal to the Supreme Court, you must appeal within 30 days. So there's a difference too. 30 days, 3 months, and 30 days. Magistrate to high court, court of appeal to Supreme Court. So don't mix up those days. The constitution of the court of appeal is 3 justices. 3 justices, that's the minimum. So 3 justices must sit on a matter. If it's a Sharia matter or an appeal from the Sharia court of appeal, the 3 justices must be learned in Sharia law. And if it's an appeal from the customary court of appeal, the 3 justices of the court of appeal must be learned in customary law as well. So important, very important. However, 1 judge can deliver judgments, but 3 justices must sit on the matter. Very important. Now, an appeal can be as of right and it can be by leave. This is provided for in the Constitution of the Federal Republic of Nigeria. So you'd see that appeals or appeal is a constitutional matter, very important. So the laid down rules must be followed. So an appeal can be as of right and by leave of court. The rules guiding appeal generally in Nigeria are the Constitution and the Court of Appeal rules. Now, there are some other applicable rules, probably the rule of the originating court, that's the trial court, the rules, and any other applicable rules. But the principal rules or legislation or guidelines are the Court of Appeal rules and the ground norm, that's the Constitution. Now, if you check section 241, subsection 1A to F, it talks about appeal, as of right. Those are the circumstances, both civil and criminal, although subsection E, which talks about the death sentence in a criminal matter, only applies to criminal matters. But aside that, subsection A to F of section 241 subsection 1 talks generally about appeal as of right. So in those circumstances, you can appeal as of right. That is, you don't need leave of court to appeal. There are some other instances mentioned, through the Constitution. If you look at Section 243, for instance, it talks about decisions of the National Industrial Court as regards fundamental human rights. That is, decisions on Chapter 4 of the Constitution. Leave will not be needed to appeal those decisions as well. If you look through another section 244 as well, it talks about decisions bordering on Sharia law. Appealing those decisions is as of right as well. Generally, if the appeal borders on law alone, a person can appeal, an appellant can appeal as of right. If you're asking the court to interpret a law or to review a decision arrived based on law, or you're asking generally a question of law alone in your appeal, then you can appeal as of right. But when you're asking a question of facts or mixed law and facts, you have to seek the leave of the court to appeal, to file that appeal as appropriate. If you look at Section 241, subsection 2 of the Constitution, in those instances listed in that section, no appeal will lie. That is, you cannot appeal those kind of decisions, or in those circumstances, you cannot appeal at all. And then you move further to Section 242, where the instances where you need to seek the leave of the court to appeal are listed and outlined. Now, seeking the leave of the court, you can seek the leave of the lower court, that is the trial court, or seek the leave of the Court of Appeal. Now, if you are seeking the leave of the Court of Appeal, it has to be that you have sought the leave of the lower court and it's been refused or denied before you can seek the leave of the Court of Appeal. And that is within the prescribed time frame. So if you seek the leave of the trial court within the time frame, for example, in a civil matter within 3 months, you seek the leave of the trial court and it's refused, within 15 days of that refusal, you have to file another application seeking the leave of the higher court, that is the Court of Appeal. Very important, 15 days after refusal, you have to seek the leave of the Court of Appeal. Now, seeking leave is very important. It goes to the root of the matter. So if it's an instance where you need to seek leave to file an appeal and you do not seek it, it can be very fatal to your case because it makes your suit incompetent before the Court of Appeal. So you need to seek leave where it is required. So who can appeal? A party in the suit, and then a non-party, that is someone that was not part of the original suit, but after the decision has sufficient legal interest, recognizable legal interest in the matter or in the decision, can also appeal. But in that circumstance, such a non-party has to seek leave of the court to appeal. The non-party will first seek leave to appeal as a non-party, and then seek leave, to file an appeal if it's a circumstance or a matter that requires the leave of court for an appeal to be filed. So 2 leaves, so to speak, must be sought in that instance. Leave to appeal is usually made by a motion ex parte, although the court can command or order a party to serve the other party, that is to come by way of motion or notice. But usually leave to appeal is sought by motion ex parte. So when filing your leave to appeal, you accompany it with your notice of appeal. Now, the notice of appeal must be headed in the Court of Appeal, although you are filing it at the trial court, but it must be headed in the Court of Appeal. That is, the normal heading, the Court of Appeal in the so-so judicial division holding at so. Now, when you have filed it, it is deemed brought, when you have brought it to the lower court. But an appeal is only deemed entered when the registrar of the lower court transmits, what you have filed to the higher court, and it is now entered in the court list of the higher court. That is when your appeal is entered. So it's important for the lower court to transmit what you have filed to the higher court before the higher court can recognize that there's an appeal before it. So the registrar of the lower court will transmit the record of appeal to the registrar of the Court of Appeal, and he or she will now enter it in the course book, not course list, course book of the Court of Appeal. And that's when your appeal has been entered. And that is the time when we can say that the Court of Appeal is seized of the matter, properly seized of the matter when the appeal has been entered. When you are filing for a leave to appeal, you file a motion asking for an order granting you leave to appeal. Then you file your notice of appeal. You file a CTC of the judgment you want to appeal. You file a CTC of the grounds for appeal. The proposed grounds for appeal. The proposed grounds for appeal. If, however, you're filing a motion for leave to appeal at the Court of Appeal after you've been refused at the lower court, then you also have to add to those documents a CTC of the court order or decision of the court refusing you the appeal at the lower court. So you add that to the things that you will file at the Court of Appeal. Now, what if you go out of time or time elapses and you still want to file an appeal generally? You need to come by way of a motion asking for extension of time within which to file or to seek leave to appeal. So if you are filing for extension of time, you need to file the following: the motion asking for the Trinity prayers. I'll talk about that soon. And then you attach to it the affidavit in support, where you explain why you're just coming to file, what caused the delay and why you're asking for an extension of time. And then you attach to it the notice of appeal and then the CTC of the judgment, the decision you want to appeal. Now, let's talk about the Trinity prayers. If you are coming to file for an extension of time within which to seek leave to appeal, where the appeal is not as of right, that is when you need the Trinity prayers. So what is the Trinity? What are the Trinity prayers? 1, an order asking for extension of time within which to seek leave to appeal. The second one is the leave to appeal itself, an order granting leave to appeal. And the third one is an order for extension of time within which to file appeal. Those are the Trinity prayers. You ask for leave, an order granting you leave to file out of time. You ask for extension of time, an order granting extension of time within which you can come and seek leave to appeal. That's 1. Then an order granting you the leave to appeal, 2. And then an order granting you extension of time within which to file the appeal itself. So those are the Trinity prayers. It can be a little tricky, but if you pay attention, you should get it, especially if it's for law school purposes. If it's for practical litigation purposes, you can always ask questions, ask your colleagues, ask court registrars, look at the rules of court over and again, and consult judicial precedents, and you will get it. There are a plethora of cases on appeals, but time will not permit me to begin to refer to them one after the other. But you should know that you should come within time. That is 3 months, and in some cases 30 days, but for criminal matters 90 days. Now, when you have gone out of time, you need to seek the permission of the court to still file. And then some appeals are as of right and some are by leave. And if you're not a party in a decision, you cannot just come. You need to seek leave first to file the appeal before you now decide is it as of right or by leave, and then you need to seek leave again if it's by leave. So that's basically all I want to talk about as far as civil appeals are concerned. I hope this answers your question. The person that asked, I will see you in my very next video. To-dos.